Welcome to Kingsdown School Creative iMedia, Unit R081, Lesson 9, Legislation. Now, legislation is just another word for laws, and our laws govern what we can and can't do in certain circumstances, and the same thing is entirely true in iMedia. There are a number of rules and regulations that are present in all that we do that are basically part of legislation that has been brought in by successive governments over a period of time, and they are there to protect people, to make sure that people are not taken advantage of, and things that are produced in the iMedia field are not copied too often is the main criteria that we are worried about, and the things that happen when they are copied. On top of that, there are rules and regulations about things like filming, what is filmed, when it is filmed, what category it comes into, whether it comes into certain certification or not. And so all of those things we need to know about before we get started in iMedia. So today's lesson is all about those laws and regulations, how they affect what we do within each of the units that we have to go through for our iMedia. Right, let's have a look.
The objective of today's lesson is to be able to understand the purpose of legislation and how it relates to the processes and procedures that we use in iMedia. The success criteria is that you will be able to identify which legislation applies to which process and procedure, and be able to ensure that compliance with the legislation has been adhered to. Okay, so why do we need to look at legislation? The exam board tells us that we must teach the learners the legislation regarding any assets to be sourced, and then of course anything which would contravene any of these laws when we are actually doing our media production. So the main things, as you can see there, that we're looking at in terms of any assets that we require to be used is that they either have a freedom from their copyright or that we have a permission. And the trademarks are not used without necessary permission, and that all intellectual property is used only where we're allowed to do so. The legislation that applies to the creation covers all of those things there: data protection, privacy, defamation, certification and classification, which a lot of people will get confused with, and there is a distinct difference between the two. The use of copyrighted material and intellectual property are also covered in this particular unit. Okay, so let's go straight away to the Copyright Designs and Patent Act. Current UK copyright law covers music, books, photos, graphics, paintings, drawings, poetry, computer programs, articles, websites, reports, basically anything at all that is written down or performed, okay, both in real terms or electronically, okay, are covered by those copyright laws. As you can see, it makes sure that the creators of that material basically retain the ownership, unless of course they sell those rights to someone else. It makes sure that you are financially rewarded for your work if it is used by someone else and it's not stolen from you. If you want to use somebody else's work, you have to have written permission, or you have to have a license for which you pay a fee, unless of course that person has actually declared that item is actually copyright free, in which case you can use it without worrying about it. So straight away I have a little task for you. I would like you to go away now and find a free image. Okay, find a free image and find an image which needs written permission, and find an image for which a fee would need to be paid. Okay, so there's 3 of those to do. Well, as normal, you can either stop the presentation and do that now, or of course you can do this as a separate exercise afterwards. So looking quickly at the Trademarks Act. Now the trademarks, some of which are very, very obvious. Okay, you can see the golden M there from McDonald's. Okay, other brand logos such as Nike and Coca-Cola are obvious ones, and it's basically any mark or logo or um, identifying feature basically that can in no way be misunderstood as being the property of a certain company realistically. There's very few that are attributable to individuals. Okay, generally speaking, these are for big companies, and the Trademark Act basically says, in a nutshell, that actually you cannot go and use that particular trademark unless you have the permission, once again, of that body that created it and owns it in the first place. Now, these ones, generally speaking, if you fall foul of this, if you do use these particular trademarks for anything that they do not endorse, they will actually take some action against you. And the consequences of that could be fines or, in fact, prison if you've been making money on the back of that and you are not allowed to. Okay. Then obviously that's taken very, very seriously by the companies themselves and by the courts. Now, brands quite often pay for product placements in media settings. So it's not that you're not going to see these trademarks, it's just that you need to make sure that they are happy for you to use them in the first place. And quite often, they will actually grant that. If it's if you were talking about say Coca-Cola and you were another large company and you wanted to use somebody holding a Coca-Cola tin in your advert, quite often Coca-Cola are going to say, well, actually, that's effectively additional advertising for us. Yes, of course, go ahead. So it's not always the case that you can't use it. You just need to make sure that you've actually got that permission again. Now the task for you on this one, find 6 trademark protected symbols. So basically 6 trademark symbols which are recognizable as being attributable to certain companies. Once again, you can stop the presentation here and go and find these straight away, or you can do this as a separate task afterwards. Now, intellectual property. This one is a little bit different because this one is basically about ideas. It's about intangible creations, i.e. you can't touch it. So it's the ideas and the creation process, if you like, pipeline designs, as in, what people were thinking about and maybe have put perhaps some sketches together for, okay, an idea in development for the new iPhone, perhaps, all of these things would be protected by intellectual property laws, okay. That protection for an idea, so that it can't be created by your competitors. A lot of people will know that when Dyson first started up with his bagless vacuums, he patented the design of the casing of the motors, and in fact for a long time the intellectual property for the idea of how the vacuum actually was being created was left with Dyson, and that meant that Dyson could continue to make those vacuum cleaners and were able to do so for a number of years before anyone else realistically could come along and say that they had something that was comparable or similar, because obviously anything too comparable would look like a copy. and that just isn't allowed. So this is exactly why we have these intellectual property laws, to make sure that somebody can't come along to a company, see something, that is sort of an idea that's coming along, or something that they've been thinking about for a while, and then go off and do that, develop it, and then try and put it forward as your own work. So we have now a task about intellectual property. Okay, it's to think about what may be protected by intellectual property laws. Okay, and then to write down on a piece of paper the types of things that you think would be covered, as opposed to the things that may not be covered. So if you can create a list of things that would be covered and those things that can't be covered. Now, there is a complete unit on the Health and Safety at Work Act, but we do need to make sure that we cover it in legislation, because it is a law, even though it is slightly more invasive than the others. Okay, it is a current UK health and safety law. Employers must protect the health and safety of all employees. So if we imagine that we are actually working for a company, straight away they are required to make sure that your health and safety is protected. It provides that the employers make all provisions that they can to make it a safer working environment. It also lays down that the responsibility of employers for maintenance, for safe entry, access and exit from buildings and from workplaces. And also it protects beyond the employees themselves. It includes the general public, visitors and temporary staff. Okay, but health and safety is also everybody's responsibility, and we'll go into that here in a lot more detail when we do the health and safety unit. Okay, so how is that done? First off, your employer would need to have an up-to-date health and safety policy, and that applies to everybody that has a workforce of 5 or more people. There needs to be the warning signs, okay, with the dangers and how to mitigate those dangers. They need to do risk assessments to find out what those dangers were in the first place. They have to make sure they have trained their staff, and they have to make sure that they have issued protective clothing and equipment where it is required. And somebody is normally allocated within the organisation to be the health and safety officer and to make sure that all that legislation is adhered to. Okay, a few risks associated with the health and safety. Um, eye damage and strain, headaches, addictions, constant viewing will cause these, back pains, mental issues, mental health issues due to stress, repetitive strain injuries, where something that you're doing is a repetitive motion, and that can actually cause wear and tear on your body. Hand and wrist injuries from using equipment that isn't ergonomically designed. And ergonomics refers to the relationship between a man and his environment. So anything that is not sort of designed to be very much complementary to the way that you do something has not been ergonomically designed and is likely to cause you problems with prolonged use. And obviously problems with posture. Um, a lot of people suffer from back aches, especially lower back ache, which quite often has no distinctive reason why that should happen. Quite a lot of people go to the doctors with this, and they are prescribed as having a backache which is non-specific. In other words, they can't attribute the pain to one particular thing, and quite often that is because of things like bad postures. The seats that they've used both at work and at home have not helped the situation. So let's just have a look at some of the dangers that you may face. Loose cables, electrocution, uh, overloaded plug sockets, risk of fire, Again, all of those come under the auspices of health and safety, and the legislation basically dictates that somebody should have done a risk assessment. They should have found out what the risks are, and you should know what you are up against. That is the main idea of any health and safety regulations. There are separate health and safety regulations for the display screen equipment. I will go through that very quickly, but as again, we go through that in a lot more detail when we do the health and safety regulations on their own. If you work for more than an hour at a time in front of a screen, then you will need to take breaks. And for those people who work for more than 2 hours at a time in front of a screen, then they need to have a care basically for how the equipment is set up to make sure that those things that we've already had a look at do not cause them a problem, i.e. eye strains, repetitive strain injuries, pain in the back from poor posture, and the regulations say that you need to have all of these things checked. You need to have eye tests, which the employers are actually responsible for paying for. Um, you must have your monitors at the right heights, your seat is the right height, have footrests, armrests, and be able to reduce the glare from the screen with special screens that go over the top. So there's a whole raft of things that can be done to make sure while you're using these display screens that your health is not adversely affected. Okay, so let's just have a look at these types of legislation again. We have things that we need to be aware of. General data protection regulations, okay, used to be known as the Data Protection Act. This applies to all information that is gathered about us as individuals by anybody. And what it basically says is that yes, you're perfectly at liberty to get that data if you need it, but it should only be the data that you need in order to do whatever it is you were going to do, either for the person or with the person. You can only hold that information for as long as it's pertinent to do so. So in other words, while it's relevant. So if you think about this, if you were, say, a customer of an online company and then you cancelled your membership, they'd probably say, well, it's reasonable to keep that information about you for perhaps, say, 6 months. If after that you haven't rejoined, then you're no longer a customer. There is no requirement for them to keep your details. So they would have to then get rid of them. What it does also cover is the storage of that information. You as a person are entitled to have your personal details kept safe, and that means anybody that takes your personal details has to undertake to keep them safely, securely, not divulge them to other people unless you specifically have given them permission. The only sort of caveat there is that you do need to be a little bit careful sometimes, because this thing about small print, sometimes within the small print it may say, if you are signing up to this, you are signing up to say that yes, they can use your data, but they could also then pass it on to other people unless you opt out. In other words, you have to tick to say that you are opting out of them using it for somebody else, not the fact where someone says in the boxes you need to opt in. So do be careful about that. The Copyright and Designs and Patents Act, as I've said already, that covers, generally speaking, the physical things that people create, and therefore it protects them and basically says you as an individual have the right to create something, and then people not necessarily be able to use that unless they have your permission to do so, and you can designate how that happens. That permission may be in terms of a license which they have to pay for, or individually, but you set the tone there. You as the person that holds the copyright actually you're able to say how that should happen. And the designs and patent bit of that is patents are basically a granting of the right to be able to produce something, as I said before, like the Dyson, where the motor was patented, so people cannot copy that particular design. They'll have to go away and come up with their own one, or they have to contact you and ask you whether they can use your design. That's what the patent is there for. Now, the Trademarks Act, as I said before, generally speaking, applies to trademarks in the forms of the logos. Those shapes, letters, words, etc., that define a company. There's very few that actually are attributable to individuals, so generally speaking, the companies that we need to worry about. The Video Recordings Act. Now, the Video Recordings Act stipulates exactly what it is that you are allowed to make recordings of, how they should be done, what classification those video recordings come into. The Registered Designs Act is again just an add-on really to the Copyright Designs and Patents Act, and this is one of those things which has been around for a long time, and again just make sure that people's designs, okay, are not impinged upon. So if you register a design and it's clearly something that is unique, then you get it registered, and once again it is very difficult for anyone then to come along and replicate it and do that and make money on it, because actually straight away if you find out about it you can go to the courts, and the courts will basically say no, any profits from that will have to be given to you because it was your design that they're using. Now, the Communications Act, that covers a whole host of things, because that covers videos, it covers TV programs, radio, telephone, and obviously computers themselves, about how they are used, what's allowed to be used on them. Things like when you've done your video recording and it's had its classification, which will say what type of recording it is. The Communications Act then also comes along and says whether in fact that needs to have any kind of warning on it. And that is the basis really of the age restrictions. So the age restrictions are governed by the Communications Act. So therefore anything that is restricted to age because of its content, that is designated by the Communications Act. So that's where the classifications and the certification comes in. If you have got something which is by its nature violent, or has an overtly sexual nature, or has a lot of drug culture in it, those kind of recordings, okay, are needing to have a certification, and that certification says that only people of a certain age group will be able to actually view them, listen to them, etc., etc. Now, the Human Rights Act you might find a little bit surprising, and that is because actually the Human Rights Act in the United Kingdom especially is effectively what sets up our privacy. We do not have any other privacy rules and regulations. We rely purely on the Human Rights Act. So therefore, if you think about that in reality, the Video Recordings Act says that you do have the right sometimes to record in public, and it states that obviously as long as you're not doing anything untoward, that there should be no problem with that. However, the Human Rights Act says that, okay, you're doing some filming in public, but that doesn't necessarily mean you can just go ahead and film anyone that happens to be in public and then have them identified, for instance. So while somebody might walk past you whilst you are filming, that would be okay. But if they come along to you and say, "I don't want to be in that. I don't, I don't wish my face to be shown," then you may need to actually respect that and put some sort of masking over them so you can't see their face. Doesn't happen very often, but obviously it sometimes does. So this is why we just need to be aware of these types of legislation. So that's why the Human Rights Act is in there. There are a couple of other things about privacy that it covers, but that's the main one. It's just making sure that those people that are in public places get the protection that they deserve if they don't wish to have their faces on publications, etc. The Health and Safety at Work Act we've already discussed, and you can see lesson 13 for greater detail. So between all of these acts and basic laws concerning the information that we create or use within the media and iMedia settings, okay, there's a basic theme to be looking for, and that is that if you are using somebody else's work, then you're going to have to make sure that you either have permission for it or you have paid the fee in terms of a license for it, or that it was declared to be copyright free in the first place so that you are allowed to use it. Now, there is another caveat here that I need you to understand, that if you have something which somebody else creates and you use a part of that, okay, and it is literally only a part of that to create something else, and therefore you have completely repurposed what the original item was designed for, as it were, then that does not require you necessarily to get a permission from the copyright holder. But as a general rule, you have to think along the lines of you're probably only talking a very small portion of. If you get to the stage where sort of like you used a quarter of it or something like that, you probably could be thinking along the lines then of, oh, actually, I need to do that. And that is especially true of things like uh, video footage and particularly songs and things like that. You can't just take somebody else's work, even and use a quarter of it and not acknowledge it and not pay for it. Now, you must also be careful that you don't publish anything that might actually damage the good name standing of an individual or a company. Okay, doing so contravenes the Defamation Act, and that would again leave you open to some sort of civil prosecution. So you really need to be aware of that. And as I said, because of the Human Rights Act, when you are creating any video footage or iMedia footage, you've got to make sure that nobody's privacy is contravened. And again, you have permission to be filming wherever it is that you're filming. Certainly if that's on location and you're on somebody's land, you need to make sure once again that you've got permission to be there. So that's pretty much covers all of the legislation that you're likely to come across when dealing with iMedia. It would be useful for you to write these acts down. You're probably not going to be required to learn them off by heart. Having said that, it certainly would be a good idea to understand that the Copyright Designs and Patents Act is one that directly affects you because of using other people's designs and work, etc., within what you're going to be doing in your units. Trademark Act, similarly, you need to be aware that that is not something that you can do. You cannot use people's trademarks, so I would avoid that completely. When you come to do Unit R089, you will need to be aware of the Video Recordings Act, the Communications Act, and the Human Rights Act. And when we're doing absolutely anything at all in iMedia, health and safety rules and regulations apply at all times, no matter what you're doing. That applies in the terms of if you were working for a company. It also actually applies to the school itself. Whilst the school has a duty of health, of maintaining your health and your safety, you similarly also have responsibilities to make sure that any problems that you encounter are reported and any safety equipment that is provided for you that you actually use. So please be aware of that at all times. I think we've covered most of this then. So using other people's work, as I said, is the Copyright Designs and Patents Act, the Trademarks Act, and the Registered Designs Act, and then the Video Recordings Act and the Communications Act. Those pretty much are the ones that you're going to have to remember. The others are need to know, of course, but not something that you're going to be asked directly about, I wouldn't have thought. Last thing there on the classification, certification, and censorship and broadcasting over the internet. Okay, those all come under the Recordings Act and the Communications Act. So I'll say again, classification. Okay, classification is basically the type of film that you are recording or the type of media that you are producing. The certification of that will depend upon the content, and that's stipulated within the Communications Act, but quite often you'll find that sometimes you'll need to actually send it off. You know, if you were to do a proper film production, and you weren't quite sure, then you may well need to send that production off to the British Board of Film Censorship, and they will have a look at it, and they will then confirm your classification and give it a certification based on the rules and regulations that they have for those particular items. So that's the bit I was talking about earlier. That's the difference between the two. Classification tells you what type of film or work you've got, what kind of media that you're dealing with, and what it appertains to, and the certification is whether in fact actually then it needs to be for a certain age group because of the content. Right, let's just move on one more. So let's just go through these definitions again, just so you got them. So data protection, it's protecting our data, as in the bits of personal information that people collect and hold about us. They have to hold only what they're supposed to hold for the period of time that it's pertinent to do so, and they have to make sure that that is safely held and is not given to other people without your express permission. Now, there is one or two organisations for which those kind of data protection rules do not have any influence. The main ones there are our security services. So the police and the national security services, border control people, all of those, they do not have to worry about these. This data protection is purely for other companies and commercial outfits. Privacy, as in our human rights. Okay, we all have that right to privacy, and therefore, if you're going to be doing some filming, you need to make sure that you have got permission to film where you want to film, and the people that appear in that film are not going to have their rights violated. Defamation, that's where you are degrading somebody's reputation or their person. That can be both as an individual and as an organization. And you do have to be careful there, things like the trademarks. If a trademark has been used, that's bad enough because the company may well obviously sue you for using their trademark. If you have used their trademark and that has portrayed that particular company in a very poor light, then that also is defamation, and therefore you can be sued again on that basis as well. So you could end up being doubly sued, and that could get very, very expensive. So certification, as I just said on the previous slide, awarding a certificate in a form of a level or standard. Okay, and that comes in the age groups, certainly for films. It comes in the PEGI ratings, if you like, for things like online games and games that are video games, etc. And the classification is agreeing that something fits a certain category. It fits into a certain genre quite often is mainly the thing for classification. That certification is whether it is appropriate for certain age groups to view. Okay. So I did ask earlier on for you to do an activity which was sourcing assets. Okay. So here we've got a couple, and you should, from what you've already done for yourselves, you should be able to tell me which are which. So having again a look at these, just tell me which one will be free, which one would require a fee, and which will just require the owner's permission for you to use in school. Okay, what I want you to do there is actually state which is which and why. Okay, so that on an email to me would be absolutely great. That way I'll know that you've understood. Certainly the legislation about the copyright. And again, just going over it again, because this is so important when you are producing your own work. Okay, you've got to make sure that you don't infringe anyone's copyright or trademark. Okay, if you're producing media for a company, then you will have to be aware of these other items. As an individual, it's really just the copyrights that you need to worry about. However, if you read the unit specifications from the iMedia qualification, you'll note that in most of those units, they ask you to act as if you are actually in a company, and in which case these other acts that I referred to earlier do come into it. So those are why I require you to remember those 5 specifically. It is because we are asked to act as if we are working for a company, and in which case when filming and recording we must make sure that we respect people's human rights as well. So I'm hoping you've got that now and understand thoroughly exactly why you've been asked to do those, but please make sure those 5 are the ones that you are most aware of. Okay, another activity for you to do now. This one shouldn't take you long. Okay, just copy the table down. Okay, and fill in the blanks. Okay, so when you're creating a logo, what activity or activities might need legislation or be, if you like, affected by the legislation. Okay, and what act is that going to cover? And you can see here I've done a couple for you. So creating a mood board, so getting pictures and examples from the internet, and here I said, right, okay, so 2, 3 and 8. So I've got to make sure I don't fall foul of the Copyright Design and Patents Act, absolutely right, or use somebody's trademark, absolutely right. Okay, and then 8, oh look, health and safety, yeah, because obviously when I'm doing anything in iMedia, it definitely covers, especially as I said, if you're working for a company, health and safety comes into it, and even when we're at school. So health and safety really should be there all the time. So I'll leave you to do that. Again, you can pause the video now, or you can do that at the end. Okay, last things now. Homework. There will be obviously a quiz as normal, titled legislation, and these 2 exam questions will be at the front of that. So as normal, I will require you to fill those in. Emailing me with a copy of the answers to these 2 exam questions would be beneficial. I will always reply to you and give you some feedback for that, so please make sure that is done. And also I would like you to prove to me once again that you have completely engaged with this particular presentation, and I would like you to email your teacher or the person who set it with the answers to this review slide. And note that obviously you will then move on to the next lesson. Okay, so I'm going to leave you now. Thanks for watching once again, and I will see you the next time. Thanks very much.